Okay, morning. So here I am. I'm outside the Victoria Gallery and Museum, which you can see just behind me. On the opposite side, of course, than the main facade. It's famous, as you know, for being the first red brick building, where we get that term of art from for some of our metropolitan institutions founded in the late 19th century. So do come and have a look. Of course, you know that there's a Maitland picture inside the gallery, so go and have a look. Well, today I thought I'd take this opportunity to talk to you about a case which is contemporaneous with the building in a certain sense, in that it's a case that dates from 1900, and of course the case is the trusts of the Abbott Fund. The citation is 1900 square brackets 2 Chancery at page 326. And of course it's a case about resulting trusts and surpluses. Why is it important? Well, because of course it's a very early authority. There are earlier ones, but it's an early authority for the successful deployment of a resulting trust. So what we have in terms of facts, there's originally a trust that's constituted by Dr. Abbott for the benefit of his 2 daughters, Frederica and Catherine, because those 2 daughters are deaf and dumb. They are incapacitated and need some help, so there's this trust that's been constituted for them. However, it's dissipated by a trustee in a fraudulent way, an inappropriate way, of course, meaning that there's a lack of funds to look after these 2 unfortunate ladies. But don't worry, because Dr. Fawcett, another Cambridge-based doctor, Dr. Fawcett, puts forward a proposal and is successful in gathering another fund, a second fund, for the benefit of those 2 ladies. However, they unfortunately die, and as a consequence there's a surplus of that fund. So the question before the court, and in particular it's Mr. Justice Stirling, is what happens to that surplus? Was there intention that there was an absolute gift by those donors, so that, for example, Catherine and Frederica could have used that money in a bankruptcy to placate their creditors, or instead, when they made those potential gifts, or donations, of course, was it in fact the case that they would have assumed that if there was a surplus, that their interests would be respected and a resulting trust would kick in for the benefit of those donors? Of course, the answer, according to Mr. Justice Stirling, is that there was a resulting trust for the benefit of those donors, and any surplus reverted back to them. So have a look at Re Abbott. We'll talk about Re Gillingham in another equity short. We'll also talk about Re West Sussex. And when you're thinking about those judgments, think about surpluses and the deployment and the idea of intention, the Van der Velde intention of Mr. Justice McGarry with presumed and automatic resulting trusts, and then the perfections that come later with Lord Brown Wilkinson in West Deutsche, i.e. the reassertion of the prevalence of the presumed resulting trust. So from here, outside the Victoria Gallery Museum, on this fine sunny day, I bid you goodbye. Goodbye. So here is our 1900 judgment. It's 1902 Chancery at page 326, as we can see here. And the case, of course, is re the trusts of the Abbott Fund, or Smith and Abbott, but we'll call it Re Abbott. So we see Mr. Justice Stirling here is the judge, who in April and May was listening to the facts in this case. And what are the facts? Well, if we look here, we see our catchwords, so resulting trust. We've got this fund raised for the maintenance of two individuals. And of course, as we'll see, we know they are the daughters of Dr. Abbott of Cambridge, and that's to say Frederica and Catherine. So, resulting trust, that's what this case is about, Re Abbott. We see here a very short synopsis of the facts in the headnote, where a fund was raised by subscription for the maintenance and support of two distressed ladies, namely the deaf and dumb children of Dr. Abbott, that's to say Frederica and Catherine, and at the death of the survivor of them, a portion of the fund remained unapplied. So there's a surplus. What happens to that surplus if the activity can no longer be carried out, namely the maintenance of those two individuals? So here we see the held section. There was a resulting trust of the balance of the fund for the subscribers thereto. So we're told pretty clearly exactly what the outcome is. And here comes our facts section. We're given the facts here as the date, the late Dr. Abbott of Cambridge, we see, and his activity in causing this trust to be raised for the benefit of his daughters. There they are, Frederica and Catherine Abbott. But of course we know, when we look at these facts, that alas, the fund is dissipated. So Dr. Fawcett, who we can see down here, appeals to the public for another fund to be raised. So in other words, the trustee of the first fund breached his fiduciary duty and dissipated the first fund. So a second fund is raised, as we can see, for the benefit of the Mrs. Abbott. And here it is. Thank you for your kind contribution of. I beg to inform you the subscriptions are deposited at the bank of Messrs. Mortlock and Co. and will be disposed of under the advice of two friends of the family. But, as we know, there's a surplus. So the question before the court, and in particular before Mr. Justice Stirling, as we'll see, is to what extent should there be or if at all, a resulting trust for the benefit of the subscribers. So here we're progressing through the facts here. We mull on these, then we get to counsel's argument, of course, just here. And then after counsel's argument for the petitioners, we come to the judgment. And here it is of Mr. Justice Stirling. And when we mull on the judgment or look through the judgment, what we'll see is that, of course, there is a lack of application of the fund. There is this surplus. And then, of course, Mr. Justice Stirling holds that so far as the fund that hasn't been subscribed or used, there is a resulting trust for the benefit of the subscribers. And when we pass down through the judgment, we see that stated here. So there must be a declaration that there is a resulting trust of the monies remaining unapplied for the benefit of the subscribers to the Abbott Fund. So read this case thoroughly, think about it, and then see how you might deploy it in the context of resulting trust where there's a surplus. Goodbye.